I'd like to welcome everybody to the meeting of the Harwich Conservation Commission for November 18th, 2020. The meeting is being conducted by remote participation, and I'd like to start by reading a notice from Governor Baker's office on such meetings. Pursuant to Governor Baker's March 12, 2020 order suspending certain provisions of the Open Meeting Law, Mass General Law, Chapter 30A, Section 18, and the Governor's March 15, 2020 order imposing strict limitations on the number of people that may gather in one place. This meeting of the Town of Harwich Conservation Commission on November 18, 2020 at 6:30 p.m. will be conducted by remote participation. Specific information and the general guidelines for remote participation by members of the public and/or parties with a right and/or requirement to attend this meeting can be found at the Town of Harwich website at www.harwich-ma.gov. For this meeting, members of the public who wish to watch the meeting may do so via recording on demand on the Harwich Channel 18 website or on our Town of Harwich YouTube page. So welcome, hope everyone's doing well. The first item on the agenda is a request for an amended order of conditions for 177 Forest Street, map 31, parcel C2, SC 32-2247. This is in order to replace some old hardscape and the installation of new hardscape. Is Mr. Saffron with us tonight?
Yes, he is.
Okay. If you would like to describe what you're looking for in terms of the request for amended order.
Okay. What happens here is I need to replace hardscape there on my property because it was all ripped up when the foundation went in, the new one. So what I'm looking to do is replace sidewalks with sidewalks, but for instance, the space around the driveway in front of the barn, it was all rubble before. Replace it by a terrace, and there's three sections that are going to go on to the terrace, connect it. One is to the barn, one is to the old house, and one is to the breezeway. On the other side, I'm just going to go down what I have here. On the east side of the barn, there was a 4-foot wide stairway going down on the whole side of the barn. And what I'm going to do is replace it with a 12-foot by 6-foot deck off the breezeway on the first floor. And then when I put in the new house, or replace the old one, I have a door from the cellar now, and I'm going to be replacing, or actually adding in front of the door, and then stones going to the back of the barn. On the west side of the barn, I'm going to, I've already, the whole foundation has to be dug up, so I'm just going to replace it with a wall around and then have appropriate planting to the barn. In back of the barn, there was a wide rubble driveway that went along the back of the barn. The back of the barn basically had 4 different bays. What I'm going to do is put back 2 2-foot wide tire tracks, and then on the other thing was the along the driveway that is currently existing, I'm going to have to put some kind of lattice work, brickwork, so the driveway does not keep dumping sand to the bottom. I've got to establish it there. On the north side of the new house, there's a door there. I'm going to have to put in a landing with 5 stairways, and then also a area which is very small platforms for my generator, electric generator unit, and then air conditioning unit. That's going to go in the back. Any questions?
Thank you.
Amy, can you hear me?
Yeah, Amy, do you want to provide a summary for us on this?
Sure. So my comments kind of are the same as last time, in that we don't typically approve, or we don't approve projects and then ask for a site plan. Though I appreciate Mr. Safran's efforts in putting, sketching on his proposed hardscape, this much hardscape in the 50 to 100, some of it within the 0, within 60. We don't typically vote to or look at these plans until it's really been put on a professional plan. And even when talking about the previous square footages of the hardscape that was there, Mr. Safran did acknowledge that they were approximations. So that is kind of difficult when talking about, work in the 0 in the 50 to 100 and talking about how much mitigation needs to potentially be done is hard to compare what was there to what is proposed now, when we really don't know exactly how much was there. So, and we don't grandfather square footage. It's been gone for several years now, at least. So my recommendation first is that we have this on a professional site plan before we can vote on it, so we know, is your deck 60 feet or is it 58 feet on the back of the house to the resource? Is what are we looking at in terms of square footages for mitigation to require of you, et cetera? I don't think we can approve of this as is. I'm sorry.
Thank you, Amy. We can run through comments from the commissioners. I guess we should ask Mr. Safran if he has plans to provide that information that Amy just asked for.
I'll need to do that, yes, if I want to get this approved.
Okay. All right, before we talk about a continuance, I guess I will ask the commissioners if they have any specific comments. I know some of them came by the site today. I'll start with you, Mark.
No, I just agree with what Amy had to say.
All right, thank you. John, you're next.
Yeah, I agree with what Amy had to say. And to be a little more specific, I would not be comfortable with approving this project until there is a plan that we can use as a point of reference to see whether the actual construction as built is what we approved in the plan. That's currently not possible with the sketches and the enumerated narrative on the document and a kind of arm-waving walk around at the property today. I just think we need something very specific that we can refer to in the future to determine compliance. Thank you.
Thanks, John. Carolyn, you're next.
I agree with Amy and John walking around today. It looks like it's getting there, but we need documentation.
All right, thank you. Jim?
Yeah, I don't have any further comments. I agree with Amy's assessment of it.
All right. Next is Ernie.
Yeah, the issue that we struggle with constantly on this property is what's being done and what's been done as well. When we were out there today, we asked to see where the mitigation plannings had already been done. And I mean, we pointed to certain areas, but for the life of me, I couldn't see any new plantings there. Obviously, they're native plants, so they would blend in, hopefully, with the existing landscaping. But what I'd love to see is a final plan, not just for what he's going to be doing next, but everything that's been done, showing what plannings have been done, what sort of mitigation has been done. Just a complete plan for this entire lot. And I know that, Steve, you mentioned today that every time you got to go back to an engineer or landscape architect, we're spending more money for you on this thing. But if you could just have some architect do up the entire plot, showing what the additions have been, what you're planning to do, what the mitigation plannings have been done so far, the amount of the mitigation planning that's been done so far, any additional mitigation planning that you're planning to do with the new additions that are on this thing. I mean, give it to us all at once. This piecemeal stuff is just, it's very confusing for me. And I think it just lends itself to a lot of frustration on each of these discussions that we have with you on this property.
Okay, right now I plan to go to Clark because he's the one that did the original one, that showed the setbacks. I'll talk to him and find out when he can get those updates completed. I might have some trouble, connecting to him because of the COVID, but once I do that, I can get back to Amy and then we can put down an appropriate time to meet when he said he'll have that done.
Okay.
Yeah, I think we're all as anxious as you are just to get this behind us and get all these approvals in place and the ducks lined up and everything else. But that'll go a long way, in my mind anyhow, to getting to that point.
Good.
Thanks, Ernie. Stan, any comments?
Yeah, I'm sorry. I missed a lot of this because I wasn't getting any sound. I had to leave the meeting and reboot, get back in. I got back in when John was talking, so I heard John, and I agree with John and Ernie both. I have no further comments.
All right, thank you. So it sounds like we're going to wait for you, Mr. Sapper, and see when you can come back to us. Amy, should we continue to a specific date?
I wouldn't, because it depends on the timing for the engineer and everything else. And we've already had a few continuances here. So you can vote to continue it indefinitely. And then when Mr. Safran is ready to, has everything all set and ready to go, then he can let me know. He will have to re-notify his few abutters, but there would be no other fee, essentially. But I think you should continue indefinitely, and then when he's ready, we'll put him on an upcoming agenda.
Sounds good. Thanks, Amy. Okay, well, I'll move that we continue indefinitely the request for an amended order of conditions for 177 Forest Street, map 31, parcel C2, SC 32-2247, and we'll go into a roll call for votes. Those in favor say aye, starting with Mark.
I'll second that, and aye.
Oh, thank you, Mark. Perfect. All right, John?
Aye.
Carolyn?
Aye.
Jim?
Aye.
Ernie?
Aye.
And Stan.
Aye.
And myself, Brad Chase, aye. Okay, the motion carries. Next on the agenda, we have 7, Ketchikannet Way, map 4, parcel C14, was a notice of intent for proposed pier, ramp, and float in the Herring River. I think we learned today they request to have a withdrawal without prejudice. Is that correct, Amy?
Yes, that's correct. The attorney did mention that he didn't think that we needed to vote to let you withdraw without prejudice, but I think to keep it clean, and we've always done that, I think if you vote to close the hearing and let them withdraw without prejudice, I think that would be appropriate.
Okay. Any further feedback on why this project was withdrawn? It had been continued for a very long time. I know the letter didn't really give much insight into anything that came up otherwise.
The only correspondence I've had with them is very little, and it was just that they were trying to find a design that would better meet the conditions or the regulations. So that's all I heard.
Yep, okay. All right, well then I move that we close the hearing and allow the notice of intent to withdraw without prejudice for 7 Ketchikannet Way, map 4, parcel C14. And I'd like to ask for a second on that motion.
I'll second it.
Okay, seconded by John. So we'll do a roll call. All those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan.
Aye.
And myself, Brad Chase, aye. So the motion carries. Okay, next on the agenda, we have a notice of intent for 46 Indian Trail, map 34, parcel K3-2. It's a proposal for a new dwelling with appurtenances. Do we have a representative here tonight?
Yes, we have a few representatives here tonight. So let me
Okay.
just Amy.
Yes, please.
Lynn Hamlin, with Betsy Bray, and also with us tonight is David Clark with Clark Engineering and attorney Brian Wall. This hearing was continued from the last time. There's been a few hearings, but specifically for a couple of reasons. One was to revise the plan so that all construction was located outside of the 60-foot setback to the resource area. And the plan that you have hopefully in front of you, dated 10/27/20, shows that. So now all construction conforms to your setback requirement. Amy and I also talked a bit about potential ways to address the 2-to-1 mitigation requirement. And as it's just physically not possible to do it on site from the nature of a vacant undisturbed lot, we were exploring off-site mitigation, and we talked about different ways to maybe accomplish that. Amy felt that donating to the Shellfish Seed Fund wasn't a close enough nexus in resource area types. I agree. So we looked into perhaps donating to the Harwich Conservation Trust restoration project of the Cranberry. It's a big project in town. And I approached the parties in that group, and they had a meeting after a fashion. COVID's making everything take longer, and declined our offer to donate. So we came back to being stuck with an inability to conform to the 2-to-1 mitigation. So we sought help from attorney Brian Wall, and he has submitted a letter to you, and I'm going to let him take it from here and speak to that. Maybe.
I don't see Attorney Wall on the call.
Let me see. I'll text him.
He's there. I see him.
We have the
You?
video. You just,
Yeah, all right.
he's muted.
We're used to Zoom. This is a little different.
Why he's not up on my screen?
I don't see him either.
It shows on my screen right below Carolyn on mine.
Brian, you have to physically unmute yourself.
If you're on a phone, it's *6.
I'm on the computer. Can you hear me?
There you are.
Okay. I'm going to try to share my camera. I tried it a minute ago, and for some reason, I'm sorry, I've never used GoToMeetings, and it put the camera the other way as opposed to my face. It was going around the back. Just give me one second.
I just made you presenter, Brian, so you should be able to share your screen.
Oh, okay. And that would that put me on the line? I'm just trying to get my camera on.
Oh, it lets us see your computer screen if you choose to. You can share whatever you're looking at on your computer with us, if that's what you're trying to do.
You have to go right up to webcam and hit share my screen.
I apologize to everyone for this. I've always been using, I have been using Zoom.
Brian, is there a figure that you wanted me to show everybody and I could do that?
No, I just have a presentation to make. And so maybe I'll just do it without you guys seeing me. Is that okay? I'll try one more time to turn the camera on. It just doesn't seem to be coming on. All right, I apologize. I don't want to delay more. May I just give the presentation verbally? Okay. So for the record, my name is Brian Wall. I'm an attorney. I have an office in Sandwich, but I practice in wetlands all over the Cape. And I'm here tonight with Lynn representing the applicant, Elizabeth Bray, who is the owner of property at 46 Indian Trail. And as the commission knows, the applicant is seeking to construct a single-family dwelling. And I understand from talking to Lynn and to the applicant that at the first hearing, there were some concerns expressed by the commission with regard to whether or not the project complies with what's called the resource area protection regulation. And in order to not twist my tongues, I'm just going to call it the buffer zone regulation because it regulates the buffer zone. And more specifically, the concerns were with regard to the 2-to-1 mitigation requirement when that is applied to new construction on the vacant lot. Essentially, the concern is that the applicant can't provide the mitigation because the entire lot is already naturally vegetated. So I was retained to look into this matter. I have 2 points that I'd like to make to the commission tonight, both of which I think provide the commission an analytical path to approving the project. And by way of review, the first argument that I'd like to make has to do with what's called statutory construction. And that's when lawyers and courts look at laws and regulations and interpret them in a case-by-case situation like this. And if I'm unable to persuade the commission with regard to my statutory construction argument, then I'd like to talk about the criteria for a variance. So excuse my voice, I got a little bit of an allergy. So beginning with the statutory construction, the regulation, as I said, has a requirement that there be 2-to-1 mitigation for work within the 50 to 100 foot area of the buffer zone. And if this is read in isolation, it would appear to prevent the project. But when lawyers and courts look at regulations, they're not interpreted in isolation. They are interpreted by what we call rules of statutory construction. And I want to paraphrase 3 of them that I think apply in this particular instance. One is, all provisions of a regulation are read to be consistent and harmonious. They're not read just in isolation. Secondly, every part of a regulation is to be given effect. No part is to be deemed superfluous. And third, a regulation is interpreted to avoid an absurd result when it is susceptible to a sensible result. And so, as I've mentioned, the focus appears to be on this 2-to-1 mitigation requirement. But there are 2 other provisions in the buffer zone regulation that I think are very pertinent to the particular situation. And I'm going to paraphrase them. I did submit a letter, so this is all in the letter that I gave to the commission. So the first part of the regulation I'd like to paraphrase is as follows. It says, to that end, these regulations, among other things, specifically require the maintenance of a 50-foot no disturb zone landward of the edge of any protected resource. In certain circumstances, such as in the application for a new home on an undeveloped lot, the Commission may also require the establishment of a vegetated buffer strip of 5 feet in width in addition to the 50-foot no disturb zone of specified width between the development activity and the protected resource. The second provision I'd like to cite is the following. When citing a new building or in addition within the 50 to 100-foot buffer zone, the structure shall be set back at least 60 feet from the resource area to allow for passage between the building and the 50-foot buffer and to avoid the intrusion of lawn in the 50-foot buffer. So as you can tell from my verbal emphasis, these two provisions clearly provide for construction of a new building on a vacant lot. And so I would submit to the Commission that if the 2-to-1 mitigation requirement is read literally and strictly and in isolation, it would actually be in conflict with and would nullify the other two provisions. And that would violate the rules of statutory construction. As I said, under the rules, the regulation is supposed to be read harmoniously, taking all of its provisions into account. And I think there's a very sensible interpretation as follows. When it comes to instances of new construction on a vacant lot, obviously there should be a 50-foot no disturb zone. There's also this extra 5-foot vegetated buffer strip in addition to the 50-foot no disturb zone, where if the Commission deems it's necessary and feasible. And third, structures, new structures that is, have to be set back at least 60 feet from the wetland resource. So I would submit to the Commission that when this regulation is read all comprehensively and harmoniously, this project can be approved with those conditions. I have the second part about the argument, which is the variance. Should I stop here and ask questions, or should I proceed on to my next part?
I'd say proceed.
Okay. So I'm hopeful that the Commission will agree with what I just said and see that this project actually complies with your buffer zone regulation and it's not prohibited by the buffer zone regulation. But if the Commission does feel that the 2-to-1 mitigation requirement is paramount and those other provisions don't apply, then I would ask for a variance. And in your regulations under section 0.13, the Commission is authorized to grant a variance from the strict application of the regulations. And there are 5 different sections that I think are applicable. And I'll try not to be tedious. This is all in my letter, so I'm going to paraphrase it. But first of all, section 1.13 authorizes the Commission to grant a variance, and I quote, upon a clear and convincing showing by the applicant that the proposed work or its natural and consequential impacts and effects will not adversely affect the interest protected by the bylaw. So I would submit to the Commission that in this particular case, the work is proposed is a new structure that is 60 feet back from the wetland. It's in the outer 50 to 100-foot buffer. It maintains the 50-foot no disturb zone. It won't provide the 2-to-1 mitigation, but overall, it does not adversely affect the interests of the bylaw. There are no other alternatives. The proposed house and septic system are proposed as far away from the wetland resources as possible. So I would submit that the first criteria is met and that a variance could be granted. There's another section that says the Commission may grant a variance from its regulations when it is necessary to avoid so restricting the use of property to constitute an unconstitutional taking without compensation. So if you can think back to your high school civics, or if anyone took constitutional law or history in college, the Fifth Amendment of the Constitution says that the government cannot take property without just compensation. And there's a body of law that says that if a regulatory agency, such as the Conservation Commission, passes regulations that are so intrusive in the property owner's property rights that prevents them from exercising what they have what's called a reasonable expectation with regard to the property and has a severe economic effect, that can be deemed to be a taking. So in this case, the applicant purchased the property. It's 63,786 square feet, or almost 1.5 acres. 41,000 of the square footage is upland. The applicant paid $200,000 for this property in 2016. It's a lot that was subdivided and intended for the site of a home. It's in a residential zoning district. So I would submit to the commission that the applicant had a reasonable expectation of being able to build a house. This is not swampland in Florida. It's an upland that's able to site a house. And if the 2-to-1 mitigation requirement is strictly applied, it will interfere with the expectations by preventing the construction of the house, and it will essentially render the lot valueless, therefore having a severe economic impact. So I submit to the commission that this is another basis to grant a variance. Thirdly, the commission has a regulation that says the commission may consider a hardship when it grants variances. And I'm going to quote from your regulations, so there's a definition of what it is. A hardship is considered to be the occasion when literal enforcement of the provisions of the regulations would involve a substantial hardship, financial or otherwise, to the applicant. The hardship may be due to circumstances relating to the soil conditions, shape or topography of the land or structures, especially affecting such land, but not affecting general zoning district. In this case, the zoning district that the property is in is the rural residential zoning district that spreads throughout the town. And I would argue to the commission that this particular wetlands condition is not generally affecting the district, but is affecting this particular property in a special way. And that literal enforcement of the regulation will involve a substantial financial hardship because of this condition. So there's a third basis to grant the variance. Finally, the fourth basis says that the requested relief may be granted because there'll be no substantial detriment to the public good, and because there will be no nullification or substantial detriment to the bylaw. And let me take the first part first. I would say to the commission that when the regulation is concerned about substantial detriment to the public good, in the wetland setting, that I think is something like if this house were to be constructed, it might flood the neighbors, or it might adversely affect rare species habitat or marsh or something to that end, something that benefits the public good. But in this case, as argued, we're at 60 feet from the wetland, the 50-foot no disturb is preserved. There will be no flooding, there'll be no detriment to the public good. The second part of that sentence says there'll be no adverse effects to the environmental interest protected by the bylaw. I've kind of covered that in my other arguments. Again, the buffer's maintained. There's an extra 10 feet because of the 60-foot requirement. We would submit to the commission, and I would rely upon Lynn Hamlin to back me up on this, that there's no adverse effects under the wetlands bylaw. So in summary, I think that this project does not need a variance because I think that, as I argued, a reasonable interpretation of your buffer zone regulations allows this project, because of the 60-foot distance and the 50-foot no disturb being maintained. But if you're not persuaded, there are multiple grounds to grant a variance. And I would submit that in this particular case, this is really the poster child case for a variance, because this lot is a nice lot to be built upon, and if there's not a variance granted, it would be rendered valueless. I'm available for questions.
All right, thank you, Mr. Wall. Amy, do you have it? Oh, excuse me.
I'm sorry, I just didn't know. Betsy wanted to make a statement. She's the one
sorry.
impacted by this, and she'd asked that she could just make a statement, and I'd like to give that opportunity.
Yeah, please.
Can everybody hear me?
Yes.
Can everybody hear me? Okay. Good evening. I'm Betsy Bray. I'm a retired library administrator. The last 12 years, my home's been here on Cape Cod. I'm a longtime member of the Harwich Conservation Trust, a member of the Chatham Conservation Foundation, and I serve as first vice president of the Friends of the Cape Cod National Seashore. I work for the Cape Cod Modern House Trust, a group that preserves mid-century modern houses on the Outer Cape. I have lectured all over the world, including Brooks Library, on the children's author and illustrator, Beatrix Potter, who was a well-known land conservationist. In 2016, I purchased the lot at 46 Indian Trail. At that time, there was a conservation permit in place. I was going to design and build a small one-floor home for myself in retirement. My plans changed and I put the lot on the market. When the conservation permit expired in 2019, the commission voted against renewal. Since then, I have worked with David Clark, our engineer, to redesign the plot plan to meet all the new regulations. Voting against this permit will cause me personal and economic hardships, as the lot would be unbuildable and therefore unsellable. I think you'll agree I'm indeed committed to conservation, and it's my sincere hope that you'll review my application and approve this permit for the reasons I've stated. Thanks.
Thank you. Okay, if we could hear from Amy on any summary comments that she has.
Sure. Is there anything else, Lynn, Betsy, Brian, David, that you want to say?
I don't want to be redundant, and I wasn't here from the beginning, but I just would like the commission to remember that this project did have a permit. I have so many clients that come to me buying property that just isn't a buildable lot, and Betsy didn't do that. She bought this property with a permit in hand, and then she ended up having to revise a plan, pay for additional engineering to make it conform to the current standards. And I don't think, I think it is a hardship or a sense of fairness when there's a regulation that can't be met. It just is physically impossible to be met. And that's the stumbling block here. And I think Brian has provided a mechanism for commissioners to approve this property. And I think it doesn't come in conflict with your regulations or set of precedents.
Thank you.
And actually, I think I might have figured out my camera. Here I am. And Amy, you directed that question to me as well. And I would just like to add that what I said in my presentation is a summarization of a letter that I submitted, and I hope that the commissioners take a look at that letter. And I would like to simply pick up on something that Lynn just said a second ago too. Under that argument about a taking, one of the prongs that the courts look at is, did the property owner have a reasonable expectation of building on this property? And as I said in my presentation, this isn't swampland in Florida where you get out of your car and you're 3 feet into a swamp. As Lynn said, this property was fully permitted. So when Mrs. Bray purchased it, she had every expectation of building. And then there's this regulatory change that has changed that. So I would, again, admit that it's a poster case for a taking, and that then provides the commission authority to exercise its variance granting authority to provide some relief from that.
Okay, thank you. I'll try to keep my comments as brief and to the point as possible. So first, I think we can all agree that Betsy and her team have gone through or have exercised and tried to find every possible way to mitigate and also to minimize what you are proposing on this lot. This lot, though it isn't swampland as you say, Brian, it does have a certified vernal pool abutting it, partially on it. That's one of the wetlands that we have here. However, the lot itself, where the house is proposed, is high and dry. That being said, taking everything kind of off the table, I think what the commission we should boil down to is what you're proposing going to have a negative impact to that habitat, and would not being able to mitigate have a detrimental effect. So that being said, and with all the arguments that you've made as well, my recommendation is approval of the project, and this is why. First, I do believe the applicant has gone through the process of trying various ways to mitigate and improve the situation, either by going to the Harwich Conservation Trust. I know that you are speaking with the town's real estate and open space committee potentially as well. You know, you've engaged Lynn to work with me about trying to find other ways of mitigating. We thought about that shellfish possibility, but again, it's two different, completely different types of resource areas. And we also, so for our mitigation, we do consider offsite mitigation like you were trying to find. We also are in the process, but haven't gotten there yet, of setting up in lieu fees. And because we haven't gotten there yet, that's not an option. We don't have that mechanism for you just yet. So because of that, I don't think you should be penalized for that. You did have a permit when you purchased the property, albeit the regulation did change in 2018. I just do find that if the commission, my professional opinion, if the commission were to deny this, it would be very hard I think it would be difficult for the commission to win, seeing as all the things that have already been stated that the applicant has done here. Let me see what else. I do think conditioning the project could, if by approving the project, the commission can condition the project. The courts would not condition things such as no chemical application within the 100-foot buffer zone. They're not going to condition, most likely, completely, you know, using native plantings, even for stuff like foundation plantings. They're not going to condition things like irrigation, other things like that the commission might want to condition. So, and then lastly, I think the work is pushed up as far to the cul-de-sac, I think, as it can be. So when you look at habitat, in my mind, critical habitat, the closest critical habitat is really down near the wetland itself, immediately in the vicinity of the 50-foot buffer zone there around it. Up closer to the road where you have the cul-de-sac, other homes, maybe not as significant. So for those reasons, and it was a difficult thing for me to come to as well, but I would recommend you grant the variance and approve the project.
Thank you, Amy. All right, let me run through comments from the commissioners, and I'll start with Mark.
I remember looking at the plan that was prior submitted, and I also recall the hearing when the order of conditions on that job was not allowed to be continued. I supported the continuance at that time because it was pretty obvious to me that any changes to that plan were going to be very, very minor, and we would have had to review anyway. In my estimation, the applicant has made more than reasonable effort to try substantially and significantly to make this comply, and I do not see any reason to not support this going forward. And you know, time and again, I've heard the expression of the word hardship, and if there's a denial here, to me, this is hardship with capital letters. So I'm very much in favor of it, and I would recommend we go forward.
Thanks, Mark. John, you're up.
I have no comments at this time.
Okay, Carolyn.
Well, I actually disagree with our attorney on one of the things he said, that there is a clear and convincing showing that it will not adversely affect the interests of our bylaw. I disagree with that. I think that it will adversely affect the interests of our bylaw. On the other hand, the size of the disturbance versus the size of the lot is relatively small. And I'm looking at the numbers here on the building coverage, and I'm a little confused whether this building coverage will be 15%, 5%, or 6.1% of the entire lot, the disturbance. If that could be clarified, I'd appreciate it.
I think Dave, I mean, I can read Dave's plan, but Dave might be better suited to address it.
So what is the percentage of disturbance on the lot?
If you bear with me a second, I will find that.
Now, you have numbers in the upper right quadrant of the diagram you submitted?
Yes, so the actual building coverage on the
No,
entire lot.
I'm asking for the actual disturbance coverage.
So permanent alterations are 2,500 square feet out of the 60.
63,000.
Yeah.
Okay.
Yep.
And that is the 15% or 6%? Well, it really doesn't.
No, that is not. That 15.6% is the disturbance of the buffer zone only, not the entire lot. It's 6.1% of the entire lot.
The entire lot. Okay, so because that number is small, I don't see a substantial detriment to the public good. And I do feel that if we were to deny this, it is an unconstitutional taking without compensation. I think there's a substantial financial hardship here. So those are my two thoughts.
Thank you, Carolyn. Jim, you're up.
Yes, I agree with Carolyn that I do see there's some adverse impacts to the resource here and that a variance would be needed. I remember at one point there was talk of a nitrogen removal septic system going in here. Is that still being proposed, or is that or not? That's a question for the applicants.
It is not being proposed at this time. Groundwater is actually flowing away from the resource area. We went out and did additional hand borings because groundwater was so high last winter when we started the re-permitting of this project. So I wanted to make sure the septic system was a minimum of 5 feet above the adjusted groundwater. So we did a couple of test borings out at the street, and the groundwater was actually lower than the water that was in the wetland. So I think groundwater in general on the south side of the Cape flows to the south. So I did. At one time, we were considering IA technology, but in this particular case, whether it's IA technology or not, it would have no impact on the resource.
I'd like to just elaborate a little bit. The town of Harwich is unique in that the health department, Board of Health, will not grant a variance for new construction. So this system complies with Title V in town of Harwich health regulations. And as such, under the regulations of wetlands regulations, it's presumed to protect the interests of the Wetlands Protection Act. And the system is located outside of the 100-foot buffer.
Yeah, I was more proposing it as a form of mitigation, as you know, there's an abundance of evidence that every one of these that goes in has a general adverse impact on water quality in the area. So it's you know, it's can be considered a form of mitigation. Another form of mitigation we've been using, and we actually have the approval of one of these later on our agenda tonight for a very similar project was to have a conservation restriction for the area outside the limit of work. That's something the commission has allowed as mitigation on similar projects in the past, and it seems like that could possibly be a good fit here as well. Any feedback on that from the applicants?
David Clark here. We did consider that at one time, but I think there's a provision in your regulations that say volunteering not to disturb a portion of the property doesn't count as mitigation.
Yeah, I'm familiar with that portion of the regulations, but I don't think that we have in multiple instances the past couple of years accepted that type of restriction on the property as a form of mitigation.
I think we talked about it a little bit. I don't think there's an issue with it. We was talking to Brian. You have to have somebody oversee the restriction, and I believe Harwich Conservation Trust, Amy, you said owns the abutting property.
The trust and the town have properties abutting, and either potentially could hold the restriction.
So I don't think that's prohibitive, and there's nothing that jumps out at me as that being a problem.
Yeah, just it's an extra layer of protection. Even though we have a 50-foot no disturb zone, it is that extra layer of protection. And it also, with conservation restrictions, whoever holds them is responsible for monitoring them. So these sites might be checked a little bit more often if they had a CR on them versus just kind of an inherent 50-foot no disturb, don't touch it to the owner.
I don't see that as impeding the applicant and the homeowner, and it does provide you with a extra level of security.
Well, yeah, I think that's a reasonable form of mitigation on this lot, and something that I would look favorably on. That's all my comments for now.
All right, thanks, Jim. Ernie?
Yeah, thanks, Brad. I've got a number of comments and questions on this. Let me start at the top. Brian, you mentioned early in your comments that the regulations have to be read harmoniously and all taken in total, and no part of the regulations is supposed to be superfluous. You've admitted that that you're meeting the requirements for the 50 and 60-foot buffer zones, and that your suggestion is that we're making the 2-to-1 mitigation ratio paramount. And I'd suggest to you that no, we're making all of the regulations paramount, and it just so happens that the one that's outstanding at this point is the 2-to-1 mitigation ratio. So we're not singling that out as being necessarily the end all and be all of this particular one. It's just the one that we're most concerned about right now, because it's the one that obviously we're having the most difficulty figuring out how to meet. I think originally when I looked at this, my first reaction on this particular piece of property was, it was purchased in 2013, that it was incumbent on the purchaser to do due diligence and make sure that it could be built on. And it's obviously she has done that, and that the permissions that were granted to her expired or were not renewed in 2019. Amy, do you know why those weren't renewed?
To my recollection, and we could go through the minutes, but my recollection, it wasn't renewed because primarily the regulations had changed in 2018, and those regulations could have had an impact on the approval of this project.
Okay, that's too bad. Because we've had other lots, I'm thinking of Permakeen especially, where we've been approached for a renewal on that, and there've been a lot of discussions around whether or not it's personal property. A number of the members of the commission said that they didn't favor renewing them simply because of the nature of the lot that was there. I don't necessarily think that was, and we did ultimately renew that one. And it would seem to me that that wouldn't be necessarily solid ground in this particular case not to renew them either. It seems to me in the past that we've sort of grandfathered approvals based on regulations that were in place at the time. If there had been some mitigating circumstances that the property wasn't built on or whatever else, which we really haven't addressed in this case yet. You know, there was also a comment about there being no adverse impact on the public good. I take exception to that too, because I think that, you know, what we're faced with here in this particular situation is some pretty pristine native habitat that will be destroyed. There's no question about it. When you put a house on a lot like this, it destroys native habitat. And our goal, our remedy for that is to have offsetting mitigation, which we can't do. So I do think this has, prima facie, some negative impact on the public good. You know, the only grounds that I see for a variance here is what's been discussed before, and that being the financial hardship. Conservation restriction on the outside of the limit of work, yeah, that's good, but ultimately we have jurisdiction over probably the majority of that lot anyhow. And you know, I'm not sure that a conservation restriction will do that much for us other than give us the opportunity to go out and make sure that there haven't been any activity taking place on it, and that just is an extra burden on Amy and her staff. So I'm not necessarily in favor of that. So all that being said, you know, the fact that this was previously permitted, the fact that the fire commission allowed it to expire just on the basis of new regulations that came in place, I don't think is necessarily a good set of facts from my perspective. And I tend to agree with Brian that the basis for a financial hardship in this particular situation is probably pretty strong. And I would tend to be in favor of that. Now, all that being said, we've struggled with this issue of offsetting mitigation. And I'd suggest to people too, we might want to talk a bit about these bogs we have over on Bank Street, or off of Depot, the Bell's Neck bogs. And, you know, we have a lot of work that's going to be done in those bogs that will cost money. And it will be a burden on the town, obviously. And I don't know whether or not the applicant would be willing to consider some sort of a contribution to the work that we need to do over there. You know, we talked today when we were at the site that there are no adjoining lots or anything like that where we can do mitigation. But I'm not sure that our mitigation has to be on an adjoining lot. And that's something I'll leave to Amy too, whether she has any comments on that. If not, and you know, that we could have some help with the Bell's Neck bogs, then perhaps that would be the remedy that we need to improve this. That's all.
Yeah. Mr. Chair, can I comment on that?
Absolutely.
So while I think that is a great idea, we don't have the mechanism yet to accept that. And I also, when we do have that, when we create that line item in our budget, we have to be very specific about where we're going to use, where those funds are going to be used for. And certainly the management of the Bell's Neck bogs would be top on my list for those things. I hesitate to, I wouldn't recommend it necessarily in this case. One, we don't have the mechanism yet to accept those funds. And also it could come off to some as if we're permitting this if you donate this, you know, directly to a commission managed property. So it just has a little bit of a hint of a conflict of interest there to me. So
I guess what I was suggesting, Amy, was that the mitigation be done on the Bell's Neck bogs. Not that it be a quid pro quo necessarily, but just that we offer the the land at the Bellemex Bogs to do the 2-to-1 mitigation.
I'm not sure. Well, one, I don't think we can right now because we don't have it in our budget for in lieu, and any type of acceptance of in lieu fees.
I think Amy's struggling with it's this, if you donate a shrub, it's still money until you set up your fund and set parameters to that. I think that's
exactly.
Yes.
Yeah. I'm hoping we can do that. In the future, we'll be working on that for this coming town meeting, have a public meeting about it.
Yeah, we talked about that, Ernie. That's what we started with, and Amy just couldn't figure out a way to do that, which is why we approached the Harwich Conservation Trust, thinking we could give them money, but they declined. So I think that unfortunately COVID has stalled that for you. And I think that will be a mechanism in the future for you. It's just, it's unfortunate that Betsy's caught in this time period.
Through the chair, may I also make a comment?
Sure.
Ernie, on behalf of the applicant, I really liked when I heard you say that you felt that this case presented a hardship and justified a variance. What I would respectfully say is that determined that the strict application of the regulation prevents development, then you kind of analytically bounce yourself into the analysis of variance. The variance really is there a hardship? Is there an interference with reasonable expectations? Is there a severe economic impact? When you talk about the mitigation, you're talking about the buffer zone. When you're talking about hardship and impact, you're talking about the taking. So I'd like to kind of what you said about the taking and run with it and say that it sounds like you're in favor of a variance. And then if you are in favor of the variance, you don't have to get into the mitigation requirement, because that would be to comply with the buffer zone regulation.
Fair enough, Brian. I hear what you're saying. Thank you.
All right, let's move on to Stan.
Yeah, there's a lot of pros and cons. Everybody's mentioned them. I guess in my case, the key issues, I think, were that this, right or wrong, from the prior commission or whoever, was approved as a buildable lot, even though the regs did change and the building didn't take place above and beyond, when before now. In addition, I think all the efforts to comply with the new regulations, all the work that's been done by the applicant has, I think, gone above and beyond what a normal person would have to do. And therefore, I think I'd be in favor of the variance. But at the same time, I want to go back to what Amy originally said, is to make sure that we put the conditions on the approval of this, on this project, as to what we think really need to be done, like the fertilization conditions, and I'm trying to think, there were a couple others, I think, but that's all I have at this point.
All right, thanks, Stan. Excellent commentary, really. I think there's just great points have been made, and I appreciate everyone's, opportunity to move this along. And I guess from my standpoint, I like some of the comments Jim said. I have concerns about how this property will impact the resource area. It's a little, corridor where the house and the deck are going to come very close on all sides to the buffer zone. And what I've seen again and again and again is that properties get approved with this close proximity, the properties change hands, and then the new owners come in and they intrude on the no disturb zone. It's just so common in the town of Harwich. My problem is, I'm the old guy, I've been around for a long time, I just see it over and over again. And so we can permit this, we can make it work, but I really worry about what happens in the future. because the places where humans are going to be walking and hanging out in back of the house are going to be just so close to the no disturb zone. So I do feel that impacts will occur. I think that the conservation restriction, even though in some ways redundant, I think could be an extra hook to help. Maybe there's some ability to have some plantings, to have a natural wall or something like that along the boundary. Otherwise, I worry about encroachment in this location over time. So I guess I do favor Jim's proposal for a conservation restriction, and I do think that it's real difficult to mitigate at this point without having an in lieu fee program established. So I guess I'll ask if there are any comments from members of the audience at this point. Okay, seeing none. A lot has been said. I'd like to circle back to see if others have comments. John, do you have something?
Yeah, I just want to add to all the things that have been said and really agree with what you just said, which is one of my concerns is exactly what you said, what happens once the property is sold, which is the clear intent here, and that future owners may very well not choose to be even aware of their responsibilities. So I would favor the conservation restriction as an extra safeguard, something I presume goes on the deed along with the other actions we might take. And we might, like you said, Brad, agree to or condition that some kind of physical barrier be in place that clearly defines what is the separation between the permitted lot and the restricted area.
If I could address that to the
Sure.
chair. I think that Amy and I have done a lot of these now. I think that Amy and I could work. I think it works better post-construction. And you can do, because you don't want it to look artificial, but you could do a combination of shrub groupings or single rail fencing and do it so it's organically works along that work limit line. So it's a physical barrier so people have a visual cue of to avoid creeping, but you don't want it to look like a corral. But I think you could condition it that we submit just a boundary plan or a landscape plan to demarc the boundary. I think that might help people feel more confident.
That's actually exactly what I was going to chime in with. We have a conservation restriction later on the agenda tonight for a very similar, very similar project. And we have the option of a living fence or a split rail fence sometimes, and boulders can also be used. So I would recommend that. And then as far as the conservation restriction, the way we have worded it on other ones is that prior to construction, that conservation restriction be approved and recorded.
Okay.
Thank you, Amy. Can I ask a question on the living fence? Why couldn't that be considered mitigation? Couldn't we work that in a way that it was mitigation?
If the commission felt that it was mitigation, then yes, it could. I think it mitigates in the way that, it adds a natural buffer, but also serves the intent of keeping people and activity out of there. So,
yeah, I'd like, the property owner has a lot to say as to what that living fence is. I don't really favor boulders, but I think it's up to them to maybe suggest what they'd like to see there. But if it was truly a nice, row or so of shrubs that, could add some, ability to keep encroachment out, then I think I would view that possibly as mitigation.
Could I just chime in real quick on that?
Sure. Yep.
So I'm not trying to go back to my argument about the buffer zone regulation, but the sections that I did cite to you about new development provide the commission authority to add a vegetated buffer strip. So in other words, if I have an existing home there's a 50-foot no disturb zone. If I have a vacant lot and I'm going to put a new home in, the commission has extra authority to make that basically 55 feet. And so I would suggest that this vegetated living fence is something that your regulation authorizes and contemplates, and I think is a good idea. Just while I have the floor real quick, if I could go back to something the chairman was saying, it seems to me there's a concern about if this is permitted, what is the effect on the town? And I just want to quote from your variance regulation very quickly. It says variances shall be granted on a case-by-case basis and only under the provisions of this section, and in no way shall be deemed to set a precedent. So I think that for those of the commissioners that are inclined to find a variance is warranted here, you know, no lawyer or applicant will come back to you and say, well, you gave a variance on Indian Trail, you should give one here. Each variance has to stand on its own merits. And so I just want the commission to know that they should feel comfortable in that regard.
Thank you, Mr. Wall. And I'll just add the language also suggests that variances should be very uncommon, and I'm afraid they're not uncommon in the town of Harwich. It is a very serious matter, and I think that everybody has brought really good arguments on this, but I think this is a case that needed that discussion. Variances should be rare and uncommon. Anyone else have comments? Any commissioners want to revisit?
Yeah, Brad, this is Stan. One of the other conditions that we talked about, Amy, when we were at the property today was any plantings around the house or anything else could possibly be all required to be native plantings as opposed to like ornamental, non-native shrubs. So that's a possible condition.
Yes, that will be a condition if this gets approved. I think I had mentioned it a little bit earlier on in the hearing here. So.
Carolyn?
Brad, I think your points on future encroachment are very well taken. And that is a strong possibility that we've noticed all over Harwich. But I don't think we can punish Mrs. Bray for possible sins of a future homeowner.
I would agree with you. I think that's a dilemma with this. You know, some of the commissioners see impacts that we're having, you know, we're struggling whether it should be permitted, but that's just another added consideration for this. But I think you're correct. You know, we can condition a project to try to avoid those things, but to me it's rampant. It's a really big problem, and I just see it again and again. And this, to me, with this footprint, with the layout of the no disturbance zone, I see this case as being really having high potential for this happening in the future.
Brad, I think that if you give me some flexibility and Amy some flexibility, that we can work out a naturally looking demarcation line. I mean, you don't want it a row of shrubs. You don't want it to look like English garden. But I think I've done a lot of these now, and I think that if you just work it in as a condition and allow some flexibility, that you can make it look natural and, you know, emphasize it where it's important, when the natural vegetation perhaps isn't as dense right at the work limit line. But I think you'll be pleased. And I think if you put in the condition, obviously Amy has to be satisfied for the certificate of compliance. So I think you're covered that way.
Yeah, well, thank you. I do expect you two to work well together on something like this. Let's see, any other thoughts or comments from commissioners? Any more thoughts on what I said about would this qualify for mitigation by having that vegetative buffer strip? It could be important. Maybe it's not. Does anyone have any thoughts on that?
So, Brad, I think we can condition it whether or not it's considered mitigation.
I agree. Would that, if it was mitigation, would there be a need for a variance at all?
I mean, I think it's reasonable to consider the conservation restriction and those plantings mitigation in themselves.
Yeah.
I would agree.
All right, well then I would say that we're pretty close for somebody proposing a motion, unless anyone has further thoughts on conditions.
So it's a question. If we're proposing a vegetative buffer strip and we're calling it mitigation, then it seems to me you have to be explicit, quantitative about it. How big is this vegetative buffer strip? What are we requiring?
So we typically do require 2 to 1, but I think the conservation, it's hard to quantify that. I mean, we can certainly look at, I mean, it's a 5-foot wide vegetated buffer strip. My inclination, because we don't want to disturb, we have the limit of work, so it's going to be right along the limit of work. Beyond the limit of work towards the wetland, that's a natural native area that we shouldn't touch. So my thought is right at the limit of work for a vegetative buffer strip, and that a conservation restriction is hard to quantify in terms of square footage of mitigation, if you will. I do think it should count. You don't necessarily have to say this equals the 2 to 1. You can say it offers mitigation and you're permitting this project because they're offering mitigation. You have to have more or less mitigation, that you have that leeway to grant permits for that.
Well, what you are proposing, Amy, is a 5-foot wide vegetative buffer strip along the limit of work as shown on the current plan.
Hang on 1 second. I'm going to make sure that makes sense.
I think that what we started talking about was because in some areas you're not going to get 5 feet. It's just that tight. I think we were talking about demarcation line to avoid creeping. And that demarcation line will include native plantings as a living fence. Depending upon the existing conditions, once we get in there and see what would benefit best from a living fence versus perhaps a split rail, single rail fence, but so it looks organic and natural.
Yeah, there are some spots on the plan where the limit of work is right on the 50, and some places where it's a lot closer to the house. So I just said the limit of work line to give us something to work with, essentially.
Yeah, what I was suggesting with that is basically a split rail fence at the limit of work line. And I agree, it wouldn't necessarily be a continuous 5-foot strip. It would probably be clumps of plantings here and there on either side of the fence in some way that made sense with the overall project. But the main idea being that line is clearly marked to prevent encroachment, to make it obvious if it did happen, and then the plantings would offer a little more buffer and soften the aesthetics of the fence.
I'm not sure I'd agree with a fence, because that's a structure. We're basically telling them to put a structure in a 50 or a 50, 60. So
but it's the purpose.
I think that if you do a combination of things and just to prove it and make it Amy's in the board's satisfaction for the certificate, I've done one in Eastham you could look at, that it's organic and it, and it's sections and your eye looks at it and it's, it doesn't conflict with the natural setting, yet it provides a visual buffer, which is what you're looking for.
Where would you propose it begins and ends? At the front corners of the house, or?
No, I would come all the way along the work limit line.
Mm-hmm.
Okay.
Yeah,
yeah.
That's why you have to give me a little flexibility to make it look organic and natural. rather than a fence all along the work limit line or a hedge all along the work limit line. And because what's going to happen is going to be some natural, I'm sure when the lot is developed, that there's going to be a lot of areas that are already naturally dense right at the work limit line. So, I think this is easily resolved between Amy and myself, and I can submit a plan so you have a record of it. But I think that's better done, post-construction or at least post-clearing.
How do folks feel about that? Do we want to see a plan before we approve this?
I think you're better served doing it. You're better served, I think, doing it the other way.
I'm comfortable with letting Amy and Lynn work out, a plan for this post-approval.
I agree with, this is Stan, I agree with Ernie. Leave it kind of flexible for Amy and Lynn to work it out.
I know we've used the verbiage.
You.
I know we've used the verbiage before that an effective living fence shall be installed at the limit of work line. That leaves some flexibility, but makes it clear for the order of conditions that it was meant to be something that effectively marked out the line and prevented encroachment.
I'm fine with that.
Could I add some language along the perimeter of the house, from the front of the house towards the back, that where possible, it becomes a 5-foot vegetative buffer strip?
It's interesting. The back of the house actually is the furthest from the wetland. And I wasn't going to reflag the wetland, but I think that's a very conservative wetland in the back of the house, just so that doesn't, so your concern, you have a lot of room between your work limit line and your resource area in the back of the house. There's a lot of room back there.
Yeah, I guess I don't see that looking at the plan.
No?
Yeah, I don't.
It's very generous. There's a very generous wetland line back there. I mean, I think that the intent to keep it at the 50-foot buffer is pretty much ties the whole project in a very confined area anyway.
Amy, what are your thoughts on that perimeter along the house and the deck facing the vernal pool? What do you think would work best?
It's really going to depend. I'd have to go back out on the site and look at the topography and look at what's currently there. That's the spot. That's the more vulnerable spot towards the northeast side. So I can't say right off the bat. I mean, I'm more inclined to go with, native shrub plantings rather than anything too structural, but I can't say types of plants or, anything right now.
Mm-hmm. Yep, I can see that.
And the commission, once Lynn proposes something and runs it by me, I'm more than happy to share it again, with all of you for a discussion topic or something else. I think everybody, we want you to feel comfortable about it. It doesn't have to just be my decision, but we'll put together something that takes into account the topography, the existing plant life that's there, and come up with something that's going to benefit the buffer.
Right. Yeah, I would say in the past we often have a plan before us before we vote on it, so it is a little unusual. I like the concept. I think we've had very good discussion on this. I'm just thinking if there's some language that I'd feel comfortable with, order tonight, such as what Jim suggested, but maybe adding where possible, a 5-foot vegetative buffer strip is applied.
We actually, for the one that's later on tonight, I can read you the condition about the vegetative buffer strip on that one.
Sure.
Because that's Bell's Neck Road.
Mm-hmm.
So either a split rail fence or native plantings are to be installed at the limit of work line upon completion of construction. This shall be discussed at the pre-construction on-site. So for that one, there was not a plan ahead of time.
Right. Well, I certainly favor a vegetated demarcation line as opposed to a split rail fence.
Mm-hmm.
But I don't mind if, where it's very tight on the other side of the house, if the fence makes sense, then I don't mind that. But I guess I still would like to see language that says where possible that a 5-foot vegetative buffer strip is applied.
Mm-hmm.
All right, folks, it's kind of important language for the order. So, we haven't gotten to a motion yet, but if anyone had any further thoughts on that, please put it forward. Hearing none, I think I'd like to ask for a motion.
Yeah, I'll make a motion to approve the notice of intent for 46 Indian Trail, construction of a new dwelling with the conditions of a conservation restriction on the entire property outside the proposed limit of work, and a combination of plantings and split rail fence to be installed along that limit of work line, creating an effective living fence to be 5 feet wide where possible to prevent encroachment into the conservation restriction area.
Could I have a second, please?
I'll second that.
All right, under discussion, I think we would add the standard no application of chemicals and anything else.
Brad, I'm not sure that conservation restriction is necessary. I don't see what else they can do, and it seems to be, if they don't have the footage to make another buildable lot, everything else is limits of this and limits of that, and I think we're adding one layer of complication on top of it.
I think it's a really good point.
If I may? Oh,
yeah,
sorry.
Please. No,
I was going to say, what it would allow me to do is, so we're not supposed to go on to properties unless, like, if there's a violation, if somebody says there's a violation, I can't go on to a property without somebody's permission, even if the neighbor calls and says, oh, there's something going on over here. Legally, we're not supposed to be doing that. A conservation restriction would allow us access to the property without necessarily having to gain, permission every time to go onto the property. So that's the one benefit of it. And it would be something that would be annually inspected. So it's a little extra work. I think it's worth it. For what it's worth.
Thank you.
Yeah, Carolyn, I think it's a good point, and with compliance to existing regulations, this would add really nothing. But I think what I'm concerned about is that we've just seen, not very good compliance for these types of situations. And I think the conservation restriction does allow the ability to keep a better eye on it and probably inform the new property owner that there's a reason for it. So it does seem redundant, but I think that it actually could help in this case.
Okay.
Let's see, any more comments under discussion?
Yeah, Stan, do we want the wording of a split rail fence in there as part of the living fence? I didn't think we wanted that.
My thought stands, there's some locations where it could make sense, but it's not really favored by me for most locations.
Right. Well,
but I think Lynn and Amy have that idea, and so, you know, I think they can work together. And I think Jim's language of a 5-foot vegetative strip where possible kind of prioritizes that approach.
Right. And then the other condition was just use of native plantings throughout on the lot for any ornamental use.
Yes, let's add that as a condition. Okay, anything else?
No.
Okay, well then I'm going to ask for a roll call. All those in favor say aye. Those opposed say nay. Starting with Mark.
Aye.
John.
Aye.
Carolyn.
Aye.
Jim.
Aye.
Stan.
Aye.
Myself, Brad Chase, aye. So the motion carries unanimously. Thank you all.
I'll vote aye too.
Sorry, Ernie, I didn't call Ernie. Okay.
No problem.
Ernie's an aye, so it is still unanimous. Sorry about that. And again, thank you all for working towards where we got tonight.
Thank you very much.
Thank you.
Thank you everyone for your time. It's much appreciated.
Thank you.
Okay, next on the agenda, we have a notice of intent for 31 Shore Road, map 2, parcel B1-7, proposal to install a boulder revetment to prevent erosion at the toe of the coastal bank. Do we have a representative here tonight? I'm not sure, Amy, if somebody's here for this one.
If you're calling via
Yes, I
phone,
am.
star 6. There you go. You could just announce who you are. Right there. I know we have a representative from GAF Engineering who's trying to get on. How about, Mr. Chair, we just give them a few minutes and do a couple orders of conditions?
Yeah, sure. Let's do that.
So we'll get, if they're listening, we'll get back to that shortly.
Yeah, I'm here. If you can hear me, I'm trying to turn my camera on.
I can hear you,
So
Bob.
yeah, go to meeting is, yeah, it should be coming on soon.
Okay.
You can proceed without the camera if you like.
Yeah.
Yeah,
It'll
just,
come up.
if you
Sure.
need me to show anything on the screen, just let me know what it is, and I'm happy to do that.
Sure. If you have the plans in front of you,
Yep.
then that's fine. I can start the presentation. And I do have some additional pictures in the queue that I wanted to show.
Okay. Just so you know, several of the commissioners went today as well to the site. So.
Sure. So, Mr. Chairman, Bob Rogers for the record with GAF Engineering. And so this project is a boulder revetment on a piece of property that already is has 2/3 protection of a boulder revetment on the east side of the property. Okay, thank you, Amy. Still trying to turn my camera on.
Would you like me to make
so
you
at the
present?
bottom of the screen, you can see. I don't know if that's necessary, but so this property and the plan, if you see on the bottom right, it has some pictures. I have some additional pictures. So there's erosion that's taking place in this area of the property from the end of where the existing stone revetment ends to the existing stone groin on the neighboring property. And so what our proposal is to, it's 4 to 5 feet high with a 1-to-1 slope, and it's about 4 to 5 feet wide. What we're matching into is the narrowest portion of the stone groin. The further that you go to the east, and here I am, the further that you go to the east, it becomes more of a traditional revetment, with stone that is flat-faced and with chinked and armored and all that. That's not what we're trying to do at all. If I could bring up the pictures that I had in my queue. I don't know where they went. Oh.
You should be able to share your screen now if you want to, Bob.
Yeah, I preloaded these pictures. Let me see if I can get them from the USB. What we're doing is we're just going to place these boulders from the shore. There's a stack of 3 sitting on geofab, and the infill would be sand with 6 inches of sand on top, and it would all be planted with beach grass. And so at the very end of the revetment that we're tying into, it almost becomes invisible, covered with the sand and the beach grass. And so it's working on getting these, let's see. So I just had a series of pictures along the beach that would show you basically how minimalistic this is in terms of a boulder, in terms of calling it a revetment and the placement of boulders. It is, so let me see. Working on it, yes. Okay. Again, I'm sorry. So we understand that this coastal bank absolutely has, would provide the protection
We can't really hear you. We're not getting any sound.
Amy,
Mike is on, but yes, Dan, I can hear you.
No, I'm saying the presenter, I think, is left. I don't see him anymore.
Well, I see it. It says his mic's on, but he's not talking. But, well, not that we can hear. Maybe I would suggest if they're listening, to try to log out and log back in. And in the meantime, or to try there's a cell phone or there's a phone number on the agenda. You could try calling in with a phone, and it's *6 to log in.
I guess that's all we can do, Amy.
Yeah,
So-
Mr. Chair, do you want to give him a few minutes to try to do this, and we'll do orders and conditions?
Yes. Yes, so Bob, we're going to proceed, and you should try to log out and come back in, and when we see you, your mic illuminated, feel free to just speak up. Okay. I guess, Amy, if you want to bring us to one of the orders and conditions.
Yep. So we have draft orders for Ronald and Maureen Pepin at 11 Georgia Lane. It was for an elevated walk, stairway, and dock. So if you
If any folks have comments, please speak up on the order.
I don't have any comments.
I'm fine as well.
Are we all set for 11 Georgia Lane?
Any comments, anybody?
Yeah, Amy, just one question. We have in here irrigation and stuff like that. Do we really need that on this one?
I think I just left it in there in the event that they want to make that top of the bank a little bit more aesthetically pleasing, that they wouldn't do that, but we can take it out if you want.
Yeah, 8 and 9, I don't think they're necessary. That I don't think a bank's going to be changed much. If there's any room to.
Okay, that's fine.
All right, someone wants to make a motion on that order?
Yeah, so I'd make a motion, we approve the order conditions for 11 Georgia Lane with removal of provisions 8 and 9.
Have a second, please?
I'll second it. Stan.
All right, seconded by Stan. All those in favor say aye. We'll do a roll call, starting with Mark.
Aye.
John?
Aye.
Carolyn?
Aye.
Jim?
Aye.
Ernie?
Aye.
Stan?
Aye.
Myself, Brad Chase, aye. Motion carries unanimously. All right. You got one more for us, Amy?
Yeah, let's just finish the orders and then we'll go back and see if Mr. Rogers is back on. So order of conditions for Tom Smith at 47 North Road.
Go ahead, Carol. I'm sorry.
Since this work is being done practically on the river, do we need to specify any containment actually on the water?
I would say that the existing bulkhead acts as its own limit of work and containment for sedimentation.
You don't think there's a danger of any materials flying around?
I just don't see where you would put up a limit of work to begin with. I mean, you could do a siltation boom, but I think given there's an existing wall there, I think the amount of siltation is minimal. And you'll get a little bit probably into the river, but the river will take care of that in short order.
Okay. If you're comfortable, that's fine.
Yeah, Amy, the only comment I had, or question I had, was number 7. You talked about the fence around the condenser. You know, we're saying it's not permitted. I just, when I got through the whole order of conditions and all of a sudden hit that, I said, what's this all about? You know, we're not telling them to remove it or anything like that. We're just saying it's not permitted, but okay, so what?
He's got to remove it. Well, I wasn't at that meeting. I mean, I looked at it and I said, it said no fence. So, I mean, I can clarify and just say what they've started to do has to be removed, if that was the intent of the commission.
But that's an administrative issue, isn't it? As opposed to something that should be in this order of conditions?
Well, I think it should be in the order because his request in the notice of intent was to have the fence. So you're approving this plan that he gave. So I want it to be clear that, okay, his wall's approved, but not the fence that's shown on the plan.
Okay, and there's nothing else in that plan. Remember, we talked in the meeting about the outside shower, and there was some other stuff I thought he's trying to pull there too.
That was.
You said the shower was removed, I know.
Yeah, that was covered. Well, the walls, the shower head's still there.
Yeah. And that, we don't want, I mean, the whole purpose of the shower being removed was so that people don't use the shower.
Yeah. He said there was one there previously. I don't know.
So, I mean, should we condition this that the shower head be removed too?
If that was something we discussed, we can condition that. If it wasn't something we discussed in the public hearing, we can't.
Well, we talked about the outside shower, right, and he said it's been removed, but you're saying it's not.
I believe he said the enclosure was removed.
Well, that wasn't the terms of the discussion. He said the outside right shower was removed.
Okay. Well, if that was just, and I remember we talked about the outside shower and I said, and removal, so I can make sure that happens and I can put that in the order, the outside showers to be removed.
Yeah, because I think that's more of a impact.
Yeah, I agree.
Thing than anything else in this that we're talking about here. So, okay, yep. Other than that, I'm fine. Those are the only comments I had.
Okay.
All right, if we have no further comments and somebody wants to make a motion on this.
I'll move we approve the order of conditions for 47 North Road with the revisions we've discussed to item number 7.
Have a second?
I'll second.
All right, seconded by Carolyn. All those in favor say aye. We'll do a roll call, starting with Mark.
Aye.
John?
Aye.
Carolyn?
Aye.
Jim?
Aye.
Ernie?
Aye.
Stan?
Aye.
And myself, Brad Chase, aye. So the motion carries. Okay, let's see. Bob, did you make it back in? I don't see him.
Oh, Some caller 4 just left. That must have been for one of the orders. I don't
Right.
see him here either. Again, if you call in on that phone number, if you're listening, it is *6 to unmute. Oh, we have a caller 7 showing up.
That would be Bob Rogers.
Oh, good.
So I'll let you finish whatever you were doing and just let me know.
Nope, we're actually at a good stopping. We finished 2 little items, so you're up if you'd like.
All right, great. So again, my apologies. I think there was just too much going on at once, and my computer sort of crashed. It didn't start burning, but it was definitely crashing. This project is an extension of an existing stone revetment. And I think, I know I'm repeating myself, but the pictures that I have, and I know Amy's been out there, but our proposal for a 3-layer boulder, 4 to 5 feet high, 4 to 5 feet wide, infilled with sand and planted with beach grass is exactly what the condition is out there now at the tail end of the revetment. And, we're trying to extend it to the stone groin. The boulders would be placed from the land. We understand that a fully vegetative solution is the preference. We're requesting the ability for the placement of boulders as really a long-term, almost permanent solution for the toe of the coastal bank. We feel that it's going to preserve the integrity of the base of the coastal bank. It's going to continue to allow the coastal bank to transmit sand to the coastal beach, and it's going to serve as a protection, a base, a foundation, if you will, for the vegetated portions of the coastal bank going up to the top and to the lawn area. I guess having already taken up so much of your time, perhaps, Mr. Chairman, while I'm trying to get back online, perhaps if you've had the chance to review the plans, and certainly Amy has, and she's seen the site, maybe I would turn it over to you to ask your questions and any other questions of the commissioners.
Okay, thank you. We'll do that. Amy, do you have a summary for us?
Sure. So I think pretty much everybody's been out to the site. Several commissioners went with me today and some went on their own. So everyone's pretty familiar with it. So I sent an email to GAF, last week or so with some of my comments. And I think a couple of them kind of still stand today. Let me get back to that. Okay, sorry about that. So about 3/4 of the shorefront of this property was revetted a long time ago. I apologize, I don't know the exact year. And there is erosion going on at this location. I wouldn't say it is, catastrophic erosion. You're kind of on the losing side on the of a groin. And a couple of things. So, I looked at the long-term erosion rate from Mass CZM, and I mean that's really just used as kind of a guide. They're showing it's kind of almost a net zero, but when you go to the site, you can see that there is a little bit of loss going on there. We have a lot of standards that need to be met in our regulations for coastal engineered structures. We're interested to know what alternatives, have you looked at other alternatives? What you've already tried, in regards to sand nourishment, because one of the things that rock walls do is they, without sand nourishment, or even sometimes with, compensatory sand nourishment, there is a dropping of the beach. which just exacerbates erosion, wave action, and damage to the coastal bank, and in this case, adjacent dune. So I would say, at a minimum, if the commission were to consider permitting an extension of this rock wall, that nourishment be a component to the approval of this, because otherwise the beach is just going to continue to drop and compromise not only the wall that you're going to build, but stuff behind it. One of our other conditions is that coastal engineered structures have to be set back at least 15 feet from adjacent property lines to decrease the chance of disturbance onto adjacent properties. And your proposal goes right up to the property line. In this, yeah, so that's just another, and I'm just going to kind of name things to consider for talking points, and then we can go on from there. So pretty much at the property line between this property and the property to the west, the coastal bank starts to turn into more of a dune. And that has a whole different set of performance standards along with it. And, protecting the integrity of that dune is critical. So I would just look at the performance standards we have in our wetland protection regulations. Again, setbacks from property lines, requirements for fully vetting what alternatives you've tried and why other things wouldn't work. I understand that it's just an extension of a rock wall, but we should vet these things. And then the last thing I want to bring up is something that you and I had chatted about, is the use of hay bales to prevent erosion both on this property and on the property to the west. And it's not just a single line of hay bales, it's pretty much a wall of hay bales that are staked, secured back into the bank without permit. So since we're here talking about this property, and those hay bales are in the location of where you want to put the rock. So that would be the equivalent of a potentially soft solution, because it's not a temporary or not a permanent solution, but it was one that was never permitted. And it's very structural, very took a while for somebody to do that. So I can't recommend that stay, and I do potentially recommend other enforcement action from the commission on that.
Okay.
Kind of in summary, I apologize. Tapering of a wall is also something that should be considered. You're saying 4 to 5 feet high-ish. Maybe it's something the commission to consider is maybe it's that high right where it joins up with the existing wall, but gradually tapering down almost to nothing, or to nothing at the groin end, and that would also help prevent additional erosion onto neighboring properties and damage to the dune. That's all. Thank you.
Oh, okay.
Thank you, Amy.
Mr. Chairman, do you want me to respond, or do you want to continue with?
Well, if you have a specific response you want to say, please go ahead.
Sure. So it seems to me, as far as the hay bale issue, that either one or both of the landowners wanted to do that, and it's not right, and it wasn't properly permitted. But they did that because erosion was occurring at that location on both properties. And so in terms of the 15-foot setback, and so that's where the erosion is occurring. And so we're proposing to go right to the property line with the stone revetment, excuse me, and with the return in that location. And with the presence of the groin, in this particular situation, we were to be held to the 15-foot setback, then we're going to get erosion, and what we're doing, I think, is providing a protection to the adjoining property in this case, not creating a potential to negatively impact. I think it's going to be a positive impact at a adjacent property owner, and it's up to him to the abutter, to protect himself however he sees fit and in accordance with the proper filings. But just in terms of the requirement for the 15-foot setback, I think in this case we would be benefiting the abutter. And so, in terms of alternatives analysis, the landowner, I think, sees this as, well, you can see what we have out on the site right now, and you can see how, the vegetation has taken place, and the grasses have overgrown and in between and right on top of the boulders. There's probably boulders that you can't see because they're completely buried by sand, and probably that's the case as well with the landward side of the stone groin. And so, like I say, if you look on the property further to the east, that's not what you want, and that's not what we want. But if we had a 36-foot section of just a completely soft solution, I think my opinion would be that would be fine for normal seasons, maybe normal coastal storms, but in a severe storm event, that there could be much more of that coastal bank to have to repair to protect the home than if we had this foundation of base stone. So if we need to, supplement our filing, with a written, point by point of the standards, one thing I can point to is, I guess general guidelines 4B, when a coastal engineering structure is proven to be essential, which I'm not saying this is essential, but it is in character with what's there, that the commission may require small, low structures that provide protection from chronic erosion, but will be overtopped by storm waves during a catastrophic event. And so this would absolutely be overtopped during a catastrophic event, but it would prevent the need for annual or every 3 or 4 years maintenance of a fully soft solution.
All right, thank you for that. We'll proceed with comments from the commissioners, starting with Mark.
I don't have any remarks at this point.
Okay, thank you. John.
Yeah, I don't have anything to say either at this point.
All right, thanks. Carolyn?
There's a couple of confusing things here to me. Behind the proposed area, is that a dune or a coastal bank?
Landward, it's a coastal bank. That's what we're classifying it as, coastal bank. It's heavily vegetated, but it goes, straight up from the toe where we're proposing the stone up to the lawn. So we see that as a coastal bank, certainly not a coastal dune.
And you're an engineering company?
Yes, well, I work for GAF Engineering in Wareham, Mass. Yep.
And Amy, our regulations are different for a dune versus a coastal bank, aren't they?
The state's regulations are.
The state's regulations are.
Yep. Well, just how to define them. So to the west of this property is dune, in my estimation. where this property is right now is kind of right at the crux of that. And I would consider where they're proposing their solution to be a bank.
Okay, that was one of my questions. I'm confused. Is where we say we'd like a revetment tapered. You're saying you think it's more effective if it's not tapered?
No, the issue was, I believe, the separation to the property line. You require a 15-foot separation to the property line and then a 45-foot return. Excuse me, I apologize. These boulders are going to be placed, and when you're out to the site, they're stacked, but they're not chinked, they're not faced. These will be round stones. They're not gonna. It's not gonna look like a revetment with a perfect 45-degree angle, 1-to-1 slope, and it's all flat faced, and all of the gaps are filled. These are round boulders. They're just placed side by side and on top of each other with no chink stone. They're just put on filter fabric. There's no structural stone underneath, and so there's a lot of void space that gets filled in with sand, and there's a 6-inch layer of sand that we're going to put on top of these, so that it looks very similar to the end of the existing revetment, where they're partially buried and the grass grows right on top of them. That was my statement, I believe.
And how does that prevent scouring?
Well, it's not going to prevent scouring in a severe storm in between the stones. We're certainly willing to have a condition of perpetual, beach nourishment, and if there's any repairs needed for the beach grass. But when we bring it right to the property line, there is no area, because of the existence of the stone groin, where we're not going to be creating scour on the adjoining property. That I believe was my point. We'll be protecting the neighbor's property as well as.
And how did those hay bales get there?
Someone hired someone to put them there, and obviously at least one of the landowners was involved in that, and I'm guessing both, but I don't have direct knowledge of it. I certainly agree with Amy that okay, it's a soft solution, but you didn't apply for a permit. It's not a permanent soft solution. Mr. Petroni, hired us to come up with, a permanent solution and to properly permit it. So, I know when Amy and I spoke, she's going to have a conversation or send a letter or in the form of an enforcement order. That's entirely up to the commission. Our client is at least trying to be proactive in the meantime to come up with a project that is, permitted properly. And, if this gets approved or if it ends up the commission, is requiring a different soft solution to be investigated. But it was done to prevent the erosion that's occurring, and it wasn't done properly.
Well, I just have to say that it wasn't done properly. It was a big project, and it doesn't instill confidence in me that this owner is compliant. So, but that's all I have to say right now. Thank you.
Thanks, Carolyn. Jim, do you have any comments?
Just a question, and this may have already been said, but is that a was that house constructed before 1970?
Yeah, the original house was constructed in the 30s. When you look at the assessor's card, it says it was constructed in 2004, which is, absolutely not the case. I'm sure there was some type of a remodeling that was done at that point. But from what I can see, there's been a house of some fashion or another on this lot for many years. And, we're in another aspect of that, we do have a dimension on our plan that in that corner where the erosion is occurring, it's slightly less than 40 feet from the house to the top of coastal bank. This isn't, as Amy says, and as you've seen, it's a dire situation that Mr. Petroni would like to do this work this winter. But why would you wait until it gets worse? Why would you go through another winter and perhaps have a couple of storms that make the situation worse? It's better to at least start the permitting process and get to an end result that can be constructed this year, rather than just leave it the way it is. It's kind of two sides to the coin. Well, the erosion isn't that bad, and well, yes, but we don't want it to get any worse.
Is that the way you understand it as well, Emmy, that the house was existing before 1978?
Yes, yeah, I mean, right. Like I say, the 30s.
That question was for Amy?
Oh.
Yeah, I was just confirming that with Amy. Yeah.
Oh, okay. Yeah, my apologies.
I don't know the exact, I don't know if it was in the 1930s, but we have records of a house being there in the 70s and 80s.
Yeah, I was going by the deed.
Maybe not in this exact configuration. And DEP is, in terms of what is like a pre-existing, pre-78 structure, DEP has gone various directions with it, saying like, oh, if you maintain a wall, then you have a pre-78 structure. Or you have to, or in some cases at all, it's just that the new house can't be any closer to the top of the bank. But I don't have an exact year on the construction of that house, so I would have to, and I'd happily try to verify the 1930s date that was given. So.
Yeah, I was going by. When I looked in the deeds, there was specific reference, I think around 36. But certainly, we'll continue this, and that will be. I mean, Amy does. You shouldn't have to do that. That will be part of our supplement to our NOI. When we come back in writing with, we would nail that down for you.
Jim, any more questions?
Yeah, just further along that point, I think that is looked at in different ways, but from my view, it should be a remodel and not a completely new house in a slightly different location. I mean, to me, that wasn't the spirit of that law and regulation. So I'm just interested in what happened there. That's all for me. Yeah.
All right, thanks, Jim. Ernie?
Yeah, I'm the same line of thinking. I mean, the 38 feet measures to a corner of a facade, basically, that was built to cover the hatchway going down into the basement. So I'd really be interested in knowing what the footprint of the original house was, because it seems to me, as was just mentioned too, that the house should not be built any closer to the dune than the prior one was. But your measurement point there, I'd be very, very surprised if that was on the original footprint of that house. And I suspect, absent that one point, you're going to be 40 feet or more from that point on the dunes. So it puts us into a whole different ballgame too. So that's my first question. The second one I have is the drawing that you've given to us, and I'm not. Do you want us to comment on this drawing, or do you plan to come back with a revised plan?
No, this is absolutely, we want the coastal engineered structure. We're certainly willing to come back with information that assesses our compliance and non-compliance with the bylaw.
Okay.
To me, this is a kind of a hybrid.
Yeah.
Okay, because again, it's not a chinked revetment that has no gaps for plants or sand. It's got a foundation, but it's soft from the top stone up and in between. And it's so when you want a soft solution, one of the reasons is because you still want the sediment transport from the coastal bank to the coastal beach. And this will certainly do that.
Okay, because where my concern was is at the the western side of the revetment that you're planning to put in there, that you have a return that's going right up against the property line. Now, it transitions from a coastal bank to a dune on the other property. And I don't know where that transition occurs, number one. It looks like it could transition west of that groin based on the photographs that I've been looking at, in which case, you can't bring the revetment all the way over to that point. You can only bring it as far as the coastal bank exists. So I think we need a real delineation, a professional delineation of where the bank ends and where the dune starts. And then my other concern is if it is coastal bank right up to the property line, and there is dune directly on the other side of the property line, putting this return there, what will that do as far as impact to the neighboring property? It doesn't look like it would be beneficial necessarily. It looks to me like as the dune erodes, that revetment will also be undermined in that particular area. So those are the kind of concerns that I'd like to have addressed in subsequent presentations. That's it.
All right, Stan, you're up.
Okay, I've got a number of questions. One is I'd like to go back to make sure we can, not looking for an answer right now, but a clarification of the home being constructed after 78 and what are the actual regulations being? Was it a complete tear down and rebuild? Was it just remodeled or extensive renovation or what? But I think that needs to be clarified as to really whether that comes under the rules or not. The second thing, and I won't belabor this hay bale thing, but I was not happy seeing that, especially where sections of it are falling apart already, and there were bales along the beach and in the water and everything else, which was not a good condition. I know there's erosion going on there, but what is the rate of erosion? I mean, how long has that condition right where it is right now been in place? Is it something that's happening real quickly now? Or this is something very, very gradual that's been going on over time? Because along with that, I'm really not in favor of hard solutions and as opposed to soft solutions. I've seen a lot of properties along the Sound there that they've been fighting with soft solutions right along. And all I've heard is that the applicant just says, well, this is what I want to do, is put a rock wall up here or a rock revetment. And maybe that's a nice like, but that doesn't mean we should just at least not try other possible solutions first. And I guess that's all I have at this point.
Thank you, Stan. Amy, if you could frame the next steps for us, it seems like we're looking for what might be an alternative analysis and a supplement to what we have? Is that what's coming up?
We're happy to provide that. So we will absolutely provide that. And
You still with us, Amy?
she may have had to take a quick break.
Okay.
Yeah, I just saw Chad. She'll be right back. She said.
Okay. All right. Well, then I think that's probably what we're interested in seeing, is comparing what you proposed here with the soft solution in the form of a formal alternatives analysis. I think that would be helpful. It looks at performance standards as well as the regulations for both options. That would be helpful. And Amy can probably provide some detail when she gets back.
Sure, I would certainly have another conversation with her if it's, late. I would certainly coordinate with her along the way, and as we were preparing that, if that would certainly help us.
When do you think you'd like to come back? We have a fairly full agenda for the next hearing on December 2nd. Would you like to come back as soon as possible, or what are your thoughts?
Well, I think I would say, please allow us to have a continuance until December 2nd, and then I would respect your time, and if we weren't in a position to have what you need, and to have it, prior to 4 or 5 days prior to, so that Amy would have a chance to review it, then I would request a continuance prior to December 2nd. If we just don't have the things together that we feel would satisfy you. And
I'll ask her just to make sure the agenda just isn't too full at this point. Hey, Amy, how you doing?
Hi. Well, we never know what the 16th is going to be. So, and you never know what other ones that have applied might fall off. So, I would say let's continue them to the 2nd. I will need, because of the holiday next week, I would need new information by Tuesday next week. That would give me some of Wednesday to review and get it to the commissioners before the long weekend.
Right.
So just keep that in mind. But I'm okay with continuing them to the 2nd, because again, the 16th could just be just as busy as the 2nd's turning out to be. We don't know yet. So.
Okay.
Something else I wanted to mention too, I'd be interested in you talking with the owners, and if there's any documentation of sand nourishment that's been done on the property as a soft solution that they've done, would be good to know. If they haven't done sand nourishment, that's certainly something that should be looked at.
Did you mean in regard with the hay bales that were placed, or just in terms of, I'm not aware that they have an order of conditions for beach nourishment.
We actually have a townwide permit in town for beach nourishment. So any property owners, as long as they conform to the orders of conditions that the town has set, are allowed to nourish their beaches. Actually, it's kind of a unique thing to Harwich. So a lot of times when the town dredges our harbors, we offer that clean dredge material at cost to shorefront property owners, and some of them take advantage of it and some of them don't. It has to be above mean high water, and so they don't need their individual permit, and they can either, if the town has available sand, they can get it from us for a really good rate. Or it does allow them to contract out and get sand from a private source. So as part of your alternatives analysis and part of our performance standards, you're required to say what things the owners have tried in the past. And I'm curious if sand nourishment is one of them.
Okay.
And Amy, so before we continue, should we discuss enforcement actions while this is opened, or would that be a separate discussion?
sorry. We can. I mean, we'll talk about the two other properties that are not, the one that's next door and then the one that's down the beach a little bit. We'll do that under other discussion in a little bit. But while we have Mr. Rogers on the line, I mean, I'll be following up with the owner anyway, but I mean, if you want to talk about it now so he's aware and can make the owners aware, that's fine.
Okay, well, I think we should have some discussion on a fine. I think to have those hay bales put in with no authorization, no discussion is certainly something that should prompt a fine. And I guess the discussion should consider whether it should be all properties as well as the contractors who did the work, and whether the hay bales should be removed immediately or if there's a reason to reconsider that. So I guess I'll just open up the floor to other commissioners that may want to chime in on this.
Well, this is Stan. I'll speak up. I mean, I think it should be removed. Like I said, some of them are coming apart and coming off the bank. I'm not sure which ones, or, you know, if they're washing just out of one and going down to the beach on the others, but there were loose bales and pieces of the bales on the beach itself today. So I think those should be removed right away. They shouldn't be there to begin with. And I would say a fine for the property owner and the contractor. I mean, that was a terrible thing to do on the beach as far as I'm concerned. So
Thank you, Stan. Any other thoughts from commissioners?
Yeah, I'd echo Stan's thought that they should be removed as soon as possible. It does appear that certainly on the adjoining property, they were laid on top of any beach grass that was there. And, you know, if they've taken them away now, perhaps that can recover. If not, I think it's a lost cause. They have to be replanted. But I would suggest that if there has been damage to the vegetation on the dune, that also be part of the remediation, that they have to replant that.
All right, thanks.
If I may, I would recommend a deadline for removal, and that if they don't do it by that date, that they be fined daily until it is. And I would recommend, today's the 18th. I'll get a hold of them this week. I don't know, either Friday, December 4th or Monday, December 7th for removal.
2 weeks?
Mm-hmm.
Thereabouts.
They should be able to find somebody to do the work to get them out of there. For that.
Can I ask a question though, Brad?
Yes, Carol. Yeah.
If we ask them to remove the hay bales and the hay bales have already injured the dune grass and a storm comes along, are we going to have more erosion than if, I mean, is this the time of year to take those? It's a catch-22, I know. They're disintegrating on the beach. But if we take them off and they can't plant dune grass now to take,
we're actually planted in the wintertime. You do. And also, it's their, I hate to say it this way, it's their fault.
Okay.
You know? I'm sorry, that may be callous, but.
No, that's.
Well, their property is not under any immediate threat. So,
yeah.
Even a severe storm might have some consequences, but I can't see how any storm we might anticipate this winter would threaten the property, the structures, even the lawn. So I think it's a reasonable thing to do.
Okay.
All right. Well, I guess we should have a motion then on the enforcement action. If somebody wants to propose that.
I'll make a motion to order that the bales be removed from property at 31 Shore Road, completely removed, and any debris that has been scattered around the beach as a result of their installation be completely removed by Monday, December 4th. Is that the 4th?
I think she said the 7th was the Monday.
Monday, December 7th. And
Suggested Monday or Friday, either the 4th or the 7th.
Monday, December 7th, and any day that they remain or any fragments of them remain thereafter, a daily fine of $100 be imposed until they're completely removed.
And remediate the bank?
Well, that we didn't discuss that in detail, did we? So does somebody want to second it, and then we can talk about modifying it?
Also, John, what about the actual fines?
What I'm suggesting, and that's my motion, is the fines don't start until the 7th. I mean, we could impose a $300 fine now and say daily fine after December 7th.
That would be my recommendation.
That's what I'd request.
Are we looking at finding only 31, not his neighbor who's got it all the way across the front of his house?
It's a different discussion, isn't it? That's not part of
We're
it.
going to talk about that later because we're talking about 31 now anyways, so we're doing it now. We'll talk about the other two later in the meeting.
Okay, so I'll revise my motion that motion to order the owner of 31 Shore Street, right? Yes, Shore Road, 31 Shore Road, be ordered to remove the hay bales and any debris related to the hay bales completely by Monday, December 7th, and a $300 fine for every day after December 7th be imposed until all traces of the hay bales are removed, and a $300 fine be imposed now as a result of the original violation.
To the, sorry, I was going to say to the owner or contractor or both.
I would say to both of, well, the original
initial?
to both of them. I don't know about the daily fine after that. It's like that is.
I think that becomes the owner's responsibility at that point. Okay.
All right.
Well,
I'm going to
discuss remediation. So that a different discussion, a different motion.
No, I'd say add to that motion that they also have to remediate any damage that the hay bales have caused to the coastal bank vegetation.
Okay, I accept that.
and if you could add as determined by the conservation agent.
Right.
Okay.
All right, I'm going to go ahead and second that. Any other discussion? Okay, let's go through a roll call of votes, and starting with Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan. Well, did you, was that affirmative?
Aye for me.
Okay, and Carolyn.
Aye.
I just go by the order which I see you guys, and sometimes I reverse it, so I think occasionally the images shift, and that's
Oh, okay. I'm sorry, Brad.
no problem. And I, Brad Chase, I as well. Okay, so it passes unanimously, and thank you for your time, Mr. Rogers, and we'll see you on the second.
Thank you all very much.
Did you officially vote for the second? I'm sorry.
No, we haven't. So I move
Okay.
that we continue the hearing for 31 Shore Drive until December 2nd, 2020.
I'll second it.
Okay, all those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan.
Aye.
And Carolyn.
Aye.
And myself, Brad Chase, aye. So that motion carries as well unanimously, and we will see you on the 2nd or soon after.
Yes, thanks, Mr. Chairman. I'll be in touch, Amy. Thank you all so much.
Yep, thank you. Okay, so looks like we have requests for certificates of compliance. If you want to run us through those, Amy.
Sorry. Construction for 3 Littlefield Pond Road, construction of a single-family home with septic and construction of a pool and patio and retaining wall. So this was a couple years ago, there were some minor deviations. He actually ended up doing more plantings than were required. I visited the site. Everything else seems to be complied with. Beyond the home is a very steep drop off, and they have a stone wall that was permitted that acts as a very effective no disturb zone there. So while the front yard is irrigated and fertilized, they're not doing it within the 100. There's a pretty clear definition of where things start and stop. Native plantings have been in for a few growing seasons and are doing well. And I would recommend a certificate of compliance for that one. We can do them together if you want, Mr. Chair. Or do you want to do one at a time?
Yeah, that's fine.
And the second one is for Wayne and Susan Pratt at 22 Walker Woods Drive. This was an after-the-fact filing a couple years ago for the clearing of vegetation, installation of a fence, chicken coop, and patio. The cleared area was restored. So the commission ended up allowing the installation of the fence and the chicken coop, and the patio that they had put in was really formal, and the commission had allowed it to essentially be broken up and be more pervious. They elected to just remove it. There's no patio there now where you see it on the plan. I don't know, it was done a few years ago. I don't know if all the plants were installed. I know I was there at the very beginning when some were. Regardless, the area that was to be planted has grown back extremely robustly. And I would recommend that you grant a certificate of compliance for that one as well. So that one did not have the condition about chemical. Hold on, let me see if that one had the condition about chemical usage. Because for the one before, of course, we'll recommend that you do the ongoing conditions about chemical usage, but let me see. Let me open up this in Dropbox. Give me a minute here. Yes, so for Walker Woods, there is an ongoing condition of no fertilizers to be used within the buffer zone, except a one-time dose of organic fertilizers to help establish the native plantings. So obviously we're past that. So with ongoing conditions saying that no chemicals can be used for both of those, I'd recommend certs of compliance. If you have questions on them, let me know.
Any questions from anybody on these? All right, if somebody wants to make a motion to approve both, that'd be good.
I'll move to approve the certificates of compliance for 3 Littlefield Pond Road and 22 Walker Woods Drive.
Okay, can we have a second, please?
I'll second.
All right, seconded by Carolyn. All those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan.
Aye.
And Carolyn.
Aye.
And myself, Brad Chase, aye. The motion carries for both the certs of compliance. And I guess that brings us into discussion. And the first item is the conservation restriction for 61 Bells Neck Road. And I guess, Amy, you have a summary for us on this?
Sure, and Dan Croto from Moran Engineering is also, I see here, and he can chime in if need be. He was the engineer on this project. So if you recall, this is the vacant lot on Bells Neck Road, where the commission, after a lot of discussion and requirement of a conservation restriction, approved construction of a small single-family home. And prior to construction, the orders of conditions read that the conservation restriction has to be accepted by the Conservation Commission, or so this property is to be sold, and we have the conservation restriction here. I did recently put a newer version of it with, hopefully without some of the grammatical errors. But I'm most interested in, and this is, so the commission, they're asking the Conservation Commission, us, to hold the restriction on the property. And really with the exception of, you know, allowing them to walk back there beyond the limit of work. There's really not much activity approved. Took out a lot of language we see in a lot of conservation restrictions about other forms of passive recreation. No vehicle usage back there. So I'm curious if, one, they would like the commission to approve and accept the restriction. I spoke with one of the commissioners today, mentioned there was some typos and grammatical errors. Those can be fixed relatively quickly. I'm more interested in what you think of the substance of the restriction. So, provided you're satisfied, I would recommend approval of it. And if you have anything else to say, can unmute yourself.
All right, thanks, Amy. I suppose for this, we'll go through and ask for comments down the line. Mark, any comments on this?
Not yet, I'm still reading.
Mm-hmm. John, have you read it yet, or are you still looking at it?
I read about 2/3 of it today, and I don't have any problem with the substance. You know, a lot of the trailing part of it seems to me to be highly technical and not I don't believe affecting the substance of the thing. So I looks fine to me, I guess.
Mm-hmm. Okay, Jim, have you had a chance to look at it?
Yeah, it looks good to me, and I'd be in favor of accepting it.
Okay, thanks. Ernie?
Yeah, a couple questions. So there's a highlighted area in here, Amy, where we've asked them for an area delineation, I guess. Is that necessary?
Let me go into that. We had asked them for, you know, essentially a living fence along the limit of work line. Let me see if that's it.
Rail fence and native plantings and that sort of thing is what's suggested there.
Right.
Essentially, the majority of the lot, with the exception of the area around the house, I guess, is conservation restricted, right?
Correct.
So this is just meant to show the areas that would be under the restriction. I'm not sure.
Yeah, there's a plan you approved that I thought was a good exhibit. Conservation restrictions, sometimes they're all words, but we had a very good visual that Dan Croto provided us of showing an area that could be restricted, and that's what we're going to do. So keep in mind too that it's for two properties. It's for 61 and 77 Mills Neck Road. One of those is the tiny property just to the north of there. It kind of comes as a package deal.
Yeah. So the other question I have is there's a section E talks about access, and essentially this grants right of access to anybody that wants to go walking around their property.
It would.
And they're all right with that?
I mean, this was vetted by, the owner, with his attorney.
Wow. I'm surprised. I guess I wouldn't do that.
We're not going to be putting there's not going to be trails on it.
No, but somebody can go cross-country skiing through his backyard if he wants to. It seems a little overreaching to me to allow that kind of access to the general public.
We don't have to keep that in there if we don't want. I think the things that were in yellow were what I had suggested after the first iteration that they add to it.
Okay.
So it's just still in yellow.
Yeah, that's the only things. Most of it looks more like the legalese of this thing.
Yeah. I'm fine with striking the other other access by the public.
Yeah, it depends on how everybody else feels, I guess.
Are we held to what was discussed in the hearing, or?
No, we just said conservation restriction. We didn't give basically prohibiting, construction or use. Because basically that area was to be left alone.
Yeah. Okay. Anything else, Ernie?
No, that's it.
Okay, Stan?
Two things. One is just a quick question right at the beginning. So we're paying them the $100 for this?
No, that's going to be taken out. There's no money.
Okay. That was just a minor issue. But going along with Ernie's point, then, so if they sell the property, for example, and there's a restriction on it, who is it? Really the buyer beware responsibility at that point, I guess?
This will be on the deed, so it gets recorded on your deed, and this doesn't come off like a certificate of compliance for an order of conditions. It takes it off your deed. This doesn't come off the deed.
So really a lawyer or whatever who's looking at this should point that out to the buyer, what this restriction means to them.
Yeah.
Okay.
Going back to Ernie's comment about passive recreation, so that's under section B1 of reserved rights. Maybe we say item number 1, instead of just recreational activities, is the ones that are allowed. Maybe we say recreational activities by the owner of property, passive outdoor allowing the owners of the property to do these passive recreation things. That's it. What do you think about that?
Yeah, and then take out the public access piece. Yeah, that's fine.
Well, it goes back to, they put this out, I
think it's in our interest to keep the public out of there too. It's a sensitive habitat area.
Okay.
Yeah, and just think a resale stand. If you were buying a piece of property, you couldn't keep people off it.
I agree with you. I agree. That's what I'm saying. It's really the buyer has to be aware of what they're.
We took what I gave the attorney was kind of a boilerplate conservation restriction that we used on another property a couple of years ago. So it might have just appeared on there, but hopefully the owner does know.
Well, shame on the attorney for just accepting that and not.
I don't know. I gave it to them as an example. I'm not trying to throw anybody under the bus. But it's, I'll take out language regarding public access.
Yeah, I don't have anything else.
All right, thanks, Dan. Carolyn?
I think that aspect is really important, especially considering the previous applicant tonight agreed to a conservation restriction. We requested a conservation restriction and to ask them to let people ride horses through their property is a bit much. I had a question also under B. Number 7, cutting and planting of trees, shrubs, or other vegetation for fire protection. You don't think you should oversee that, Amy?
Yeah, I'll put with.
That should be done with approval of Conservation Commission? Yeah. That was my question.
I think we should actually, I mean, I want to take out removal of dead or downed because as long as it's not hazardous. So I would take the removal of hazardous, put it up there instead of, stuff for tick and disease controls and storm cleanup, because sometimes, woody debris, storm debris is really good for habitat. So I'll try to rework that language, and I'll definitely put, with permission of the commission or its agent.
Mm-hmm. And on number 4, erection and maintenance of fences that do not interfere with passage of wildlife. That would only be on the boundary, wouldn't it? Not in the middle of it.
Right. So that's just, maybe we say erection and maintenance of fences along the
boundary
of the restriction.
Mm-hmm. Yeah, we don't want them just randomly putting up fences in the middle of it.
Right.
That the horses out.
All right, anything else? I think we're all in pretty good agreement that this is to be supported. Any other comments? All right, I guess we're ready for a motion on this.
So it would be to accept or approve and accept the conservation restriction. Or 77.
Move we approve and accept the conservation restriction on 61 Bells Neck Road with revisions.
And 77 Bells Neck Road.
And 77 Bells Neck Road. Thank you.
I'll second that.
All right, seconded by Stan. All those in favor say aye through roll call, starting with Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan.
Aye.
Carolyn.
Aye.
And myself, Brad Chase, aye. So the motion carries. How you doing, Amy?
Sorry, sometimes I forget that I'm still on camera. I'm doing okay.
It's been a while. It's a long day, I'm sure. It's a long day for you.
Yeah,
And
sitting is really hard on my back and neck. So, but we're almost done.
Yeah, I think so. I think the dock and pier regulations that we really should give it a fair amount of time. And I know that I want to spend a few hours going over the information I have before I revisit it. So unless anyone objects, or if anyone wants to bounce some ideas off it, I think we wait on this until we have some more room on an agenda.
I have a question, Brad.
Sure.
At MAC conference a couple of weeks ago, there was a discussion on shading of docks in eelgrass and salt marsh. One of the presenters mentioned that the DEP is doing a study of an official study of shading for the docks, and that the results will be coming out in the spring.
Oh, interesting. I know the Division of Marine Fisheries, John Logan, published a study already that included fairly good data on that. So maybe
he was the presenter. But anyway, he definitely said that the official maybe you got we got the preview and not the official data of the same study. I don't know, but I think if more studies are coming out, we might hold off another couple of months.
Well, I wouldn't like to hold off too long. I think that the next time we have an open agenda, I'd like to see us get back to it because it's really been put off for a long time. I'm curious if you can find a link or something that speaks to that, because I wonder, is it mistaken agency, because this was recently published, or is it an independent study that looks at something a little bit different? So it might be good to know.
I tried to go back onto the MAC website, but their website last week, at least, was not up and running properly. So they weren't answering anything.
Right. And the second part of this is that we've really struggled with the shellfish aspect, and we don't have a lot of quantitative information on the scouring impact. The shading issue, there's a fair amount of agreement, I think, that we've gone to a higher height above salt marsh, and so that might not be as pressing a question as some of the other resource impacts.
It's controversial a question.
Yeah, but the more data, the better. But I do know that the published study that came out recently certainly contributed to this question, and it makes us feel better that we've been asking for a little more height in recent years for the planks. So my thought is that if we have an agenda that allows us to put some time to us, we should do it. It's not going to be December 2nd, I don't think. But I would like to, John put in some good time looking at this. I put in a fair amount of effort too. If you let it get away too far, then you might lose some momentum. I would like to see some regulation, recommendations put together, fairly soon.
Mm-hmm.
Any other thoughts on this? All right, well, we'll get back to it. It's a big one. Amy, what do you want to tackle for minutes? I don't think that you want to stay for 4 sets of minutes, or what are your thoughts?
It does. I'm here. So whatever you want to do.
All right.
Maybe first, before we get into minutes, do you want, for the 2 other properties that I think it was 27 and 39 Shore Road that had hay bales, did you want to do the same thing? Have me reach out to them, give them a deadline of December 7th for removal with an initial fine to the owner and the contractor, and then $300 a day fine if they don't have them out by the 7th?
I would agree to that. Yeah, I think that's a good idea. My only reservation is the one to the east. Is that 27?
The one to the east is 39.
That one, the hay bales looked like they'd been around a lot longer. That could just be because there was more sand blowing over them.
No, they looked older.
So I mean, I think our intent should be to find the contractor. I'm just wondering whether it would be more difficult to do that.
Oh, for that one, maybe, yeah.
That one there was a little bit different too, because it was just really, it seemed, as opposed to the other two, it was like that one row of bales kind of buried in the sand more. I mean, they were anchored, but they weren't like stacked, or it might have been because of the topography there too.
No, I think that was a single roll. I feel like that's a different contractor who probably did that. Maybe a year, they're probably a year old. And they were more at the toe, like you said, and not stacked up like a revetment wall. Certainly not staked perpendicular into the dune like these other ones had stakes through the bales at a 90-degree angle into the bank. But yeah, we may not know the contractor on that one. Who knows if I'll find the contractor on this one, but we'll do our best. So if you want, you can vote for me to take those actions, the enforcement order and the fines for 27 and 39 Shore Road.
All right.
I'll make a motion
Thanks, John.
that the owners of 27 and 39 Road be ordered to remove the hay bales that have been installed on the dune and or bank in front of their homes and all associated debris from the beach by Monday, December 7th, and a fine of $300 each to the homeowner and the contractor who did the work at each of the properties be imposed, plus a daily fine for every day after December 7th that the hay bales or any related debris remain on the beach.
And going back to Ernie's point,
Restoration.
Yeah.
And that any disturbed vegetation be replanted. But do we need a deadline for that? Wow. That they work with the conservation administrator to restore any disturbed or killed vegetation associated with the installation of the hay bales.
I'll second that.
All right, thanks. Let's have a roll call. All those in favor say aye, starting with Mark.
Aye.
John?
Aye.
Jim?
Aye.
Ernie?
Aye.
Stan?
Aye.
And Carolyn?
Aye.
Myself, Brad Chase, aye. The motion carries. I apologize for not calling for discussion. I'm getting a little punchy myself. It's been a long day.
Yeah, it's been a long day.
But let's go through the minutes.
We have 3 sets. We do not have October 21st is my set to do. I haven't finished it yet. Melissa did. I'd love to get the ones at least from July done, July 1st and 15th. Those are old. So if we could at least do those. And the executive session ones from 11/4 are basically notes from Ernie that I just put together. And those are a real quick review too, if you don't mind.
Yep, okay. I would say speak up as you can on any comments you have.
So I did the July minutes and I had no problems with them. The July 15th didn't show up until later today. I didn't get it.
Yeah, if you don't want to do those, because she did just finish them at the end of the day, she was trying, and I said, told her it doesn't have to be ready. If you want to put the 15th off till next meeting, that's fine. Or if you want to take a few minutes and go through them, you can.
Well, I did add one comment on the meeting, on the minutes from the 1st of July.
Okay, go
Amy.
ahead.
On the next to last page, the issue on Helfrich on 33 Snow Inn Road.
Hang on 1 second. Yep.
Did I really confirm the project is already complete? I know I went down there, but generally I don't do that for you.
I mean, I'd have to look at the tape, but I would say, yeah, I would think so.
Okay, that's fine. It just struck me generally, you know, we look to you for that sort of confirmation.
Yeah. Yeah, I'd have to look. I mean, it was in July, and
Yeah.
I didn't write the minutes, so.
Okay. That was the only comment
Maybe
I had
you
on that.
asked. So then it says Ernie confirms the project is already complete, and then it says Amy states it is. So maybe it's Ernie asks if the project is complete.
Could be. Yeah, that sounds.
It
more like
sounds better.
Yeah.
It sounds, yeah. Maybe you asked to confirm, maybe yeah. Okay.
Amy, under order of conditions for the July 1st, under Rockland, Jim confirms that the no chemical application condition, oh, sorry, I read it wrong. It's fine. You know what? It reads kind of funny. Jim confirms that no chemical application condition was included. That means Jim confirmed.
I would
You
say
see,
Jim
we call it
confirmed
the
that.
no chemical application, but he confirms that chemical application was not included. Was included.
Yeah, I get you.
Yeah. We should have a better name for it.
Anything else for July 1?
I'll make a motion to approve the minutes for July 1.
I'll second.
Thank you. All those in favor, starting with Mark?
Aye.
John?
Aye.
Jim?
Aye.
Ernie?
All right.
Stan?
Aye.
Carolyn?
Aye.
And myself, Brad Chase, aye. Okay, motion carries.
Do you want to, for the 15th, do you want to do them next time? Because they were just in your box a couple hours ago?
Sure.
Yeah, I
All
think
right,
so.
so let's, yeah. Can we do the 11-4 executive session minutes though?
Mm-hmm.
I have no comments on those.
Good job, Ernie.
Thanks.
It was short and sweet.
I have no comments.
Same here.
I'd move to approve the minutes for the executive session meeting of 11/4.
I'll second.
seconded by Carolyn. All those in favor say aye, starting with Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Stan.
Aye.
And Carolyn.
Aye.
And myself, Brad Chase, aye. So motion carries for those minutes.
That's all I got.
That's good. Well, I want to first recognize John Ketchum for organizing and leading a group of folks out to Skinnequit River to do some stream work there. And I thought it was really successful. And we saw, John, after you left, I went upstream. There was a bunch of juvenile herring flopping on leaves because they were all jammed up with the leaves that came down with a higher flow. But the work we did just prompted those fish to move downstream immediately. So pretty exciting to see that. They were big juvenile herring too.
Yeah.
So,
Thank you.
so Brad, a couple days later, Brian and I were walking down Uncle Vini's to the beach, and there was a couple standing at the herring run, looking at the herring run. And I asked him if he was seeing any herring. And he said, no, but he had seen a bunch of some fish name that I'd never heard, some like very colloquial sounding fish name like skinny digits or something like that.
Stickleback?
Ummychog?
Something like that. And I remember
Stickleback.
seeing very tiny minnows that I didn't know what they were, and they were moving too fast for me to even be sure that it wasn't something wrong with my eyes, but that were in the very shallow water there. And I couldn't figure out from what he was saying whether that's what he was talking about. It was a little odd. Anyway,
Yeah,
go ahead.
I did see some ummychogs downstream of the culvert there. And that's a little fish that will use the tidal waters as well as freshwater, and they'll go back and forth. But
and live in the
herring
mud?
Yeah, they'll kind of blend in with the mud. The herring are very silvery, and they were just large. They were really, they've been held up in Skinnequit Pond for a long time. And as soon as they had a chance, they came downstream. So it was pretty rewarding to see that. And thank you for organizing that effort.
Yeah, well, I was happy. I had fun that morning.
Yeah, we'll get back out and do it again. Anything else under new business? All right, folks, thank you all. I'll move that we adjourn.
Second.
All right, we've got doing one more roll call. Mark.
Aye.
John.
Aye.
Jim.
Aye.
Ernie.
Aye.
Dan.
Aye.
Carolyn.
Aye.
And myself, Brad Chase, aye. We are officially adjourned. Hey there, pup.
This conference is no longer being recorded.
Thank you, Amy.